I want to first start by acknowledging that I am grateful to live, work, and gather on the traditional, ancestral, and unceded territories of the Coast Salish peoples, including the Musqueam, Tsleil-Waututh, and Squamish nations. I want to congratulate RISE on their new report on protection orders for organizing this webinar today and for inviting me to speak with this wonderful group of co-panelists. I want to briefly discuss the early years. So from when the protection order regime first came into effect in 2013 in March, and it was the transformation and modernization of the then Family Relations Act into the Family Law Act. And it's important to remember that prior, one of the key things I want to talk about is that the context that this new legislation and protection order regime was coming into. It's important to remember that when the family law first came into force, that there was no definition of family violence in the family law legislation prior to that time. What was involved was mostly lawyers making cases and putting evidence before courts and having case law determine and advancing and expanding what family violence looked like. So I think it's important to remember that the new protection order regime was fundamentally cased in a new order which talked about family violence in a comprehensive manner. And it was done so because of the lobbying, activist, advocate, and rallying efforts of many frontline activists, transition house workers, advocate support workers, and those working in the area of intimate partner violence and gender-based violence for many, many decades before to get the legislation and the comprehensive definition we have today. And for that, I want to acknowledge all those on the front lines that made a difference in the lives of survivors of violence. The transition guide that the Ministry of Justice produced regarding what the goal of the family violence definition inclusion in the legislation was that it was supposed to give all family justice participants a clear and common understanding of what family violence is for the purpose of understanding the Family Law Act. So we had a modernized legislation that required significant learning curve for many of us in the family justice system. It required lawyers and those in the family justice system, including the judiciary, to get a broader knowledge and understanding of what the comprehensive definition meant, how to interpret it, how to define risk and harm. And those were critical in determining, that knowledge was critical in determining the key aspects of who would then end up using the protection order regime and what lawyers would require in terms of evidence to make those arguments before court. As I and others started to do training and work in the area on the ground regarding the protection order regime and around the family violence definition, what we started to hear from frontline workers, those in transition houses and shelters, was that the protection order regime was actually not being used. And that many were actually avoiding seeking protection orders and not engaging the family law system to seek safety and support. What became apparent is that there was resulting gaps and that there was a lack of coordinated effort and information. The result was the formation of an ad hoc working group made up of community frontline advocates and anti-violence workers and a few family law lawyers that all came together starting in around 2015 to create a space for discussion regarding some of the emerging issues and concerns and gaps and barriers that were identified regarding the interpretation and application and granting or not of protection orders, including how breaches of such orders were being addressed. We wanted to provide a space to discuss the many anecdotal conversations that were occurring between advocates, lawyers, and community group members and various institutions. We thought it would be beneficial to provide a space to share our experiences and information, and in particular to address the impact of the protection order process on women and children experiencing family violence. The ad hoc protection working group went from around 2015 to just around 2021 when I was going back and looking at all of the minutes and all of the organizing. And I think we were quite successful in doing some things as an ad hoc group. We held community consultation about 25 to 30 organizations representing an intersectional and diverse background in gender-based violence. We met with Legal Services Society. We met with the Ministry of Justice and policymakers. And finally, we began on working what was clearly a missing piece, which was the collection of data of survivors' experiences. And this work was spearheaded by a core member of the Protection Order Working Group, which I want to acknowledge. And I think she's here in on this actual webinar. And that's lawyer Miguel Huberman, who, along with Haley and Andrea from Rise Women's Legal Center, took on that work and started the process of what was really significant. And I'm so glad to see that the seeds of the Ad Hoc Protection Order Working Group have been taken up by such organizations as Rise Women's Legal Center in the great work in the new protection order report that is out today. The early years of the regime, I want to highlight, and the time that I have, just some of the problems that arose. The family law system in whole, again, was on a huge learning curve on the expansive definition of violence and the new protection order regime. I would say that when the definition of family violence was so expanded, there was a lot of concern about floodgates. Is everyone going to come forward now? Is everyone going to make a claim of gender-based violence? And that resulted in a bit of a pushback, I think, from the system that we could see in cases where there was a great caution, and in some cases, some would say rigidity in terms of what would be allowable. And what was deemed to be considered family violence, and what would meet the threshold of risk or likely harm for the making or granting of protection orders. So survivors of violence also at that time, again, we're looking at the period of 2013 to now. There's been more changes since, and I'll let Haley talk about those. But the early days, survivors were still talking about facing challenges getting legal aid coverage to make applications for protection orders, or not receiving enough time, and often making decisions about their legal aid hours, which prioritized needs around parenting time or child support versus safety and getting a protection order. Many still face not meeting the threshold of protection orders, and a range of early decisions from the court illustrated a struggle to recognize the risk and harm of family violence. Survivors of violence were not finding supportive or responsive family law lawyers to hear their experiences of gender-based violence. The key concerns remain some, which you'll see echoed in other reports that have still come out by Rise and others, that the key concerns were survivors of gender-based violence were not feeling that they were being believed or heard about their violence, that there was a ranging interpretation or engagement with a comprehensive definition of violence, and courts were not meeting the threshold or not feeling they could meet the threshold. Breaches were not, charges were not being laid in breaches, and limited orders for limited durations were occurring, and there was not enough resources externally to pursue protection orders. So while the Ad Hoc Protection Order Group continued to do the work of meeting with institutions and systems and frontline workers, we also were doing the work of educating and training. And in April 2016, myself and Miguel Huberman, who I already mentioned, co-chaired the Trial Lawyers Association seminar called A Rock in a Hard Place. And this was a panel, a multidisciplinary panel that was set up to look at the issue of family violence and protection orders, and to have everyone at the table. And Vanda was actually on that panel at that time. And it involved judges, Crown, family lawyers, researchers. It involved RCMP and other police. And what was illustrated from that whole panel was the incredible gaps of knowledge and shared information between various systems. The result being that the risk for harm to survivors and their children was increased. Police shared about not knowing if they had the right order or forums that would not enter a domestic situation unless they had the authority. There was a gap and delay between what family law was doing and what the police understood was what they needed in hand to actually go into women's homes when they were facing violence. There were terms of protection orders that were too vague and so then not acted upon. Judges were feeling that the threshold for protection order was too high, so defaulted to what's now called conduct orders, another mechanism newly available in the Family Law Act, and I'm not going to talk about it, but for some, it was not the appropriate order to get in terms of to prevent significant risk and harm, or did not provide the requisite required police intervention. There was orders where orders were granted, if breached, there was, again, not enough evidence to lay charges at the new criminal standard. And advocates in when the Family Relations Act and discussions of the new act, the Family Law Act, were occurring and submissions were being made, one of the main concerns advocates raised was, if we have this new standard of criminal enforcement for protection orders, will this actually become a barrier, an obstacle? And there was much debate. This was I think, one of the areas that kept many advocates who might be sitting in the webinar now, or lawyers. This was something that was one of the main concerns, and it seems to have, in practice, become an issue in terms of the significant limited amount of the significant way in which breaches are not being charged when a breach occurs. So it's important to know that there were still many fundamental barriers, and this was around 2016 to 2018. But while this was occurring, we were seeing some changes within actual cases, and the cases started to shift. And what was, I think, hopeful, which is always good to have some hope in this, is that there was more education being taken by lawyers. The judiciary was getting more informed. There were more cases coming forward. The kinds of cases and evidence that were being put forward were increasingly using social science research and making the case for the incredible the analysis for gender-based violence to be more expansive. We started having conversations of coercive control, which I know are now in the forefront for many people. And the other thing that started to happen is we started to see that fundamental shift from the family violence definition actually be engaged comprehensively in many cases. And we started to see issues of psychological violence, financial abuse, mental abuse, sexual abuse, and other forms of abuse making their ways through the legal system in ways that they hadn't been prior to. And so I think that I know that there's going to be a lot of challenging about what the system needs to do better, but there has been, I can say, some transformation in the kind of dialogue we are having now that we weren't having before the definition change. I think it's important to also remember that the purpose of the protection order regime and if you get a chance to, it's always good to see what the intention and objectives of the regime were supposed to be. And the Ministry of Justice put out a transition guide, and it laid out what was supposed to be the reason to do the protection order. Like, why did we need a new regime? And I'm not going to get into all the critiques of what happened in the restraining order regime that was in the Family Relations Act, but they were significant as well. But one of the goals is that it was supposed to provide, and this is what the transition document says, that it was supposed to provide a streamlined enforcement, and it was supposed to broaden the range of family members who are eligible to apply for protection order, clarify procedures, and ensure protection orders are accessible, clear, and effective, and provide guidance on risk factors to promote the use of protection orders in appropriate and safety-related situations. The only purpose of the protection order regime is to keep people safe from risk and harm and violence. And so if we have a regime that's not meeting that, then we need to see what's happening. And a lot of the things that the new protection order regime, the new protection order report that RISE has highlighted, really does crystallize what we need to do to make a path forward. I just want to end on one final anecdote that came out from in 2016 when I attended the panel about protection orders, at which a senior police officer acknowledged that it was only by luck that women and children were being kept safe under the then still new protection order regime. And this was a police officer that had worked in the force for over 20 years. What I want to say is that survivors of gender-based violence should not have to rely on the luck of having a lawyer that understands the complex dynamics of gender-based violence, or having the luck of a judge that will engage a comprehensive analysis of family violence, or to provide a protection order for a minimum of one duration, or the luck of having legal representation or ongoing legal aid coverage. RCMP have similar training in family violence and will show up when an order is being breached, or the luck that the breach of their orders will result in charges, or that they will be listened to, respected, supported, believed, and kept safe. This should not be about luck. This should be about creating a survivor-centered family law system that centers a trauma-informed practice, that supports and validates the work of support workers and working in collaboration and coordination with support workers and those on the front line that have been doing this for decades and decades and decades, who hear the experiences of survivors, and that we need to listen to the survivors of gender-based violence. This should not be about luck, but it should be about justice. That's it. Thank you so much.